In this video, I am going to discuss various types of contracts like valid contract, voidable contract, void contract, express and implied contract, quasi-contract, executed, executory, unilateral and bilateral contracts. I'll be dealing with types of contracts on the basis of three categories, that is enforcement, mode of creation as well as depending on execution. Now let's understand agreement and contract of the Indian Contract Act. Section 2E defines an agreement as every promise and every set of promises forming consideration for each other. Further, Section 2H defines contract, an agreement which is enforceable by law. Hello everyone, I am Apurva and you are watching Legal Bites. Now let's deal with the kinds of contract. On the basis of enforcement, there are 5 categories of contract: valid contract, voidable contract, void contract, unenforceable contract, illegal or unlawful contract. Now I'll be dealing each one of them. When we talk of valid contract, we need to keep in mind the essential requirements of Section 10 of Indian Contract Act, that is lawful consideration, lawful object, free consent of parties and competency of parties. If an agreement satisfied all these conditions, it is considered as a valid contract. I suggest you please open Bare Act of Indian Contract Act so as to get clarity on the concept. Now what is voidable contract? As per Section 2I of the Indian Contract Act, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other, is a voidable contract. As I have already discussed that free consent is an essential part of a valid contract. Consent is said to be free when it is not obtained by coercion, undue influence, fraud or misrepresentation. Where a consent to an agreement is caused by coercion, undue influence, fraud or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. Now it is very important to know that a voidable contract remains valid until rescinded. A voidable contract can be made valid by the party who has a right to rescind it by giving up his right of rescinding it. Now let's understand void contract. Firstly, an agreement not enforceable by law is said to be void as per Section 2G of the Indian Contract Act. Section 2J of the Act speaks about a valid contract which subsequently becomes void when it ceases to be enforceable. Please remember this, neither obligation nor right arises from a void contract. They are not covered by law, so parties are not allowed to make such contracts as valid by giving their consent. We know Section 24 to 30 explains void agreements. Briefly, I'll tell you which agreements are declared as void. Agreements unlawful in parts, agreements without consideration, agreements in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceedings, agreement void for uncertainty, wagering agreement. Remember, either restraint is partial or complete, the agreement will be void only. Now comes unenforceable contract. It is one which is good in substance, but because of some technical defect, one or both parties cannot be sued on it. These defects may be absence of writing, registration, time barred by the law of limitation, etc. Illegal or unlawful contract. The name itself reflects its nature. Section 23 of the Indian Contract Act describes some condition when an agreement may be unlawful or illegal. In simple words, agreements whose object or consideration is forbidden by law are known as illegal contract. You must know that all illegal agreements or contracts are void, but all void contract agreements are not illegal. So the similarity is that both are unenforceable. At least keep noting sections so that you can revise topics easily. On the basis of mode of creation, contracts are further subdivided into two categories. They are as expressed and implied contract and quasi-contract. Section 9 deals with express and implied contract. Where proposal or acceptance of any promise is made in words, either written or oral, it's known as express contract. Whereas implied contracts are entered between the party by virtue of their conduct. So in case of implied contract, the terms of agreement are not in written or oral form but are inferred from their conduct. Now what is quasi-contract? A contract which does not arise by virtue of any agreement between the parties, but due to special circumstances, the law recognizes it as a contract. Such contracts come into existence because of the inference from courts in the interest of justice. There are several situations in which law as well as justice requires that a certain person is required to conform to an obligation, although he has neither broken any contract nor committed any tort. For detailed knowledge regarding quasi-contract, you can refer Chapter 5 of Indian Contract Act. We can understand quasi-contract from a simple example. Suppose someone by mistake transfer money from his account to your account. Even in the absence of an agreement or contract, it's your legal obligation to send back that money to that individual. Now let's understand types of contract on the basis of execution. There are 4 categories of contracts such as executed contract, executory contract, unilateral contract, bilateral contract. Now let's understand each one of them. Firstly, executed contract. When both the parties have completely performed their obligation under the contract, it is said to be executed contract. And we can understand this from the simplest example of our day-to-day life, buying of goods. Now dealing with executory contract. An executory contract is one in which one or both the parties are still to perform their obligation. It is referred as future contracts. For example, delivery and payment are to be made after 15 days. Now, unilateral contract. It is regarded as one-sided contract. A unilateral promise is promised from one side only and intended to induce some action by the other party. The promisee is not bound to act, for he gives no promise from his side. And lastly, bilateral contract. A bilateral contract is a legally binding contract formed by the exchange of reciprocal promises. It is known as reciprocal contracts because mutuality of obligation is essential for its enforceability. Here we come to the end of the discussion of this topic. I hope it proves fruitful for your studies. Let's meet soon with the next video. Till then, keep working hard towards your goal and keep watching Legal Bites. Follow Legal Bites for getting subject-wise knowledge on all legal topics, mock practice series for judiciary, and much more. Please do like, share and subscribe the video. Thank you.